We have individuals come into our office all the time that have moved here from other states. And generally, if they've moved here from another state, they have estate planning documents that were drafted in a state like Indiana or Ohio or Tennessee, or from as far away as California, Oregon. And I always get the question, are our documents still any good? And generally, the first question, kind of jokingly, that I ask them is, where is your driver's license from? And they'll inevitably say, my driver's license is Indiana or Ohio or California. And I say, did you drive here to Kentucky? And they will say, well, yeah, we drove here to Kentucky. And then my next question is, then how do you know that your license was any good? It's because of the full faith and credit of the United States, and if it was legal in the state where you established your driver's license, or in most cases where you got married, or where you had your documents legally drafted, if they were done correctly in the state where you initially did them, then they're good in the state where you're living. From a practical standpoint, what I explain to people is that yes, your document is still legally binding, but in a situation like you're in emergency health and you have to go, someone needs to speak on your behalf in a hospital or talk with a doctor, and those individuals, those healthcare professionals, are used to seeing documents that are drafted in Kentucky, it might be a good idea just to update maybe your healthcare power of attorney or your living will so it matches with what healthcare professionals in Kentucky are used to seeing. But at the end of the day, they're still legally binding. They're still legally good documents if they were done correctly in the state where you lived. You don't have to go and completely redo your estate plan just because you moved to Kentucky. It's a case-by-case basis, but I would suggest that at least healthcare powers of attorney and living will you update when you move to a new state.